Can we? Yeah, we can hear you, sir. Chair of this session is Honorable Mr. Justice M.M. Kumar, Member National Human Rights Commission and former Chief Justice, Jammu and Kashmir High Court. Co-chair of the session is Honorable Mr. Justice Karunanand Bajpai, Judicial Member, National Consumer Dispute Redressal Commission. Our guest of honor, Professor Ved P. Nanda, Padma Bhushan, John Evans, Distinguished University Professor, and Thompson G. Marsh, Professor of Law, University of Denver, USA. We are also happy to have our guest of honor, a social thinker, Sri Atul Kothari ji, and our special guest for today, Mr. Rahul Goyal, a partner at the prestigious firm Anant Law. We also have with us today Dr. K. Ratnabali, who is a professor of law at Faculty of Law, University of Delhi. She is also the Dean of Academic Affairs, University of Delhi, and Professor Dr. Kiran Gupta from Law Center 2 of Faculty of Delhi, Delhi University. We extend our deepest gratitude to all our dignitaries for taking out time from their busy schedule and coming on board to interact with the students. Let me now invite Professor Dr. K. Ratnabali to deliver the welcome address and flag off the day's program.
Thank you, Mehak. Namaskar. Very good morning to everyone and good evening to Professor Nanda. Honorable Mr. Justice M.M. Kumar, Member National Human Rights Commission, former Chief Justice of Jammu and Kashmir High Court. Honorable Mr. Justice Karunanand Bajpai, Judicial Member, National Consumer Dispute Redressal Commission. Professor Ved P. Nanda, Padma Bhushan, John Evans, Distinguished University Professor, and Thompson G. Marsh, Professor of Law, University of Denver, USA, and our Honorary Professor of University of Delhi also. Sri Atul Kothari, Social Thinker, Mr. Rahul Goyal, Partner, Anant Law, our Dean, Professor Usha Tandon, Faculty of Law, Professor in charges of all the three centers, Professor Kiran Gupta, distinguished invitees.
I can't hear anything.
Sir,
can you hear me?
We can hear you, yes.
I can't, oh, okay. I can't hear you. So whenever you tell me, I'll start talking.
Okay, sir.
Because I cannot hear you.
Mehak, can you just send a text a message to sir?
I'll tell the technical team to get in touch with you, sir.
Right.
So because we can hear you very clearly.
It's 12:50 after midnight my time. Can you hear me? I can't see anybody right now. I'll start talking.
I think because of this technical issue,
sir cannot. Ma'am, sir is Sir can hear me now. Hello.
Yeah. So I will just finish the welcome address and then you can connect with Sir Mehak.
Yes, ma'am. You can please. I got in touch.
So I'll go ahead with the welcome address. So I, on behalf of the University of Delhi and Faculty of Law, as well as on my own behalf, extend a very, very warm welcome to our distinguished dignitaries on the panel who have kindly consented to be part of this invigorating discussion on access to justice, vulnerable and disadvantaged groups, linguistic barrier, which is a sub-theme of the Conclave on Indianization of legal system and education. We all know that a society has to ensure justice. Without justice, we cannot think about having a peaceful and secure society. So therefore, ensuring justice as well as having an efficient justice delivery system is concomitant to having a peaceful and secure society. Indeed, it is very important in this context to have accessibility to justice. Because even though there may be a good justice system, but unless a person is not able to access it, it is not of any value to that person. So therefore, I think today's theme of discussion, which is accessibility to justice, and then how this accessibility is being, I would say, accessibility is prohibited or at least restricted because of the socio-economic condition, because of unawareness about the law, or not having the proper mechanism to access to justice, as well as not knowing the language which is being used in the legal system, is indeed restrictions to the access of justice. So therefore, it is very important that we discuss this particular theme today. And I would also like to apprise that a study which was conducted by National Law University with the help of Law Commission came to a conclusion that there was an interview conducted of 373 death row convicts over a 15-year period, and they found that three-fourths of those given death penalty belonged to backward classes or religious minorities, and 75% were economically weaker sections. So I think it is very important and pertinent to think whether we are doing actually proper justice at our end. Are these people who are marginalized having proper access to justice? Are they able to put forward what they have to say? Because many a times in the courtroom, particularly when we talk about criminal justice system, we find that the accused may not be aware about what is transpiring, or what is the conversation that is being taking place between a lawyer and the judge. So therefore, he becomes a mere spectator and may not be an active participant in trying to defend, or say, at least voice what he has to say. Therefore, I think it's very, very important to keep in mind the ways and the techniques of overcoming the linguistic barrier. And that's why I think this particular theme of today's discussion has been carefully chosen. So to have this discussion, we have with us on our panel, as Mehak has already said, we have Honorable Justice M.M. Kumar, who has delivered many important judgments as Chief Justice of the Jammu and Kashmir High Court, as well as Judge of the Punjab and Haryana High Court. Sir also has the experience of having worked as Executive Chairman, Legal Services Authority, and Chairman, Mediation Committee, and held Mega Lok Adalats also. And Sir, as you know, is currently working as member of the National Human Rights Commission. All these positions have provided Honorable Justice the opportunity to understand the common people from close quarters. Sir also has the unique distinction of holding courts during floods in September 2014. If you look at what Sir has done, what innovative actions and enterprise he has come up with in order to ensure that justice is delivered even at such natural calamity. Having regard to the wide experience of Justice Sir, where he has had experience in working in various parts of the country where there was diverse language, culture, and socio-economic disparity prevalent. We are certain, Sir, that you shall enlighten us with the ways justice can be made accessible, crossing the barriers of language, social, and economic. We heartily extend a very warm welcome to you, Sir. We also have in our panel today Honorable Mr. Justice Karunanand Bajpayee, Judicial Member of the National Consumer Dispute Redressal Commission. He has practiced extensively in criminal matter before being elevated to the bench, and I'm sure that the experience across a range of parties and clients who may have come from different socio-economic strata. Sir, we know that you will enlighten us with the wisdom and experience you have gained on the way. We extend a very warm welcome to you, sir, for sparing a valuable time for this panel discussion. We have with us eminent Padma Bhushan Professor Vedpi Nanda, John Evans Distinguished University Professor, and Thompson G. Marsh Professor of Law, University of Denver, USA, and Honorary Professor of University of Delhi. Professor Nanda is widely acclaimed legal luminary in the national and international platform. Sir has been gracious enough to share and contribute in whatever ways he can to the Faculty of Law whenever we approach him. And we already know, in spite of the time difference, Sir is here with us today. And being exposed to various differing legal systems, your insights on the matter on discussion shall enrich the discussion. We extend a very warm welcome to you, sir. We have with
Thank
us
you.
We have with us also Sri Atul Kothari, who is a social thinker, and Sir is also National Secretary of Siksha Sanskriti Uthan Niyaz. And he has worked extensively on education. He has also worked on promoting Indian languages. We thank you, sir, for your gracious presence, and we look forward to your address. We have in our panel Mr. Rahul Goyal, partner, Anant Law. We welcome you and thank you for your gracious presence. And we all look forward to an invigorating, thought provoking, and enlightening discussion. With this, I once again welcome everyone who has joined this discussion. Over to you, Mehak.
Thank you, ma'am. Thank you so much for introducing all the guests. Now, I'll invite our guest of honor, Professor Ved P. Nanda, to start the address.
But thank you very much and deeply appreciate your having this special occasion and special program. I commend the University of Delhi for taking the time to address this very important issue. I'm a proud alumnus of the University of Delhi and was very fortunate to get first class first and gold medal there. And I am also privileged to be working with the Human Rights Center of the American Bar Association, serving on its executive board and on the international law section of the American Bar Association. It has got more than 20,000 members, but I mention them only because both of them feel very, very strongly that access to justice and rule of law, this is their mantra. And they have been deeply, deeply involved in dealing with access to justice issues. Here in Colorado, we have Access to Justice Commission, and it was formed in 2003. But this last year, they had a statewide learn after listening. So listen and learn. They did findings, they have recommendations. And very briefly, I like to mention that the issue of access to justice is not simply in one country or a few countries, it's universal. For example, as you think about this part, the United Nations began its own group of people who had worked on it, and they have a declaration of the high level meeting on the rule of law. What they said is they emphasized the right of equal access to justice for all, including numbers of vulnerable groups, reaffirmed the commitment of member states to taking all the necessary steps to provide fair, transparent, effective, non discriminatory, and accountable services that promote access to justice for all. I think the amazing part is that almost every country has in its own constitution provisions for providing access to justice. They have got statutes, they've got legislation. Problem simply is that of implementation. And as I think about this topic, because having been involved with this Colorado Commission also, because the Commission has got my former students, some very good friends who are working on that Commission. But the answer very simply is that access to justice is not simply that you provide them access to courts, you guarantee them legal representation, but it is, if you want to define it, as the ability that people have to seek and obtain a remedy through any formal or informal institutions of justice so that their grievances are redressed. And there is also a very important need, as you have rightly said, for marginalized people. Sometimes they fear the system, they do not access it, they see it as an alien, they are financially are not able to access it. It becomes inaccessible. They have no lawyers. They do not have information or knowledge of rights. It's a weak justice system. And the problem simply is that you do need legal protection, legal awareness, legal aid and counsel. You need enforcement, adjudication, civil society being involved in it. I was just looking at the Department of Justice in India that have now innovative efforts in order to ensure that in a holistic fashion that they provide access to justice. Here in the United States, the Department of Justice, 2003, 20 years ago almost, they established the Office of Access to Justice. They also decided that in criminal civil justice system, they ought to provide all kind of assistance. And they had three principles guiding them: promoting accessibility, ensuring fairness, increasing efficiency. And then they said how to translate these three into reality. And they decided that they would have advanced new statutory policy practice changes, that they would promote less lawyer intensive and court intensive solutions, but at the same time, they would provide alternatives. They would expand research, they would do innovative strategies. And very briefly, I might mention this Colorado Commission that I have been very closely associated because of friends who have been working on it. This one, after going to about 40 places, 41 places, more than 500 community stakeholders, and they realized that there is still gap in the system. Justice gap is there, and in order to provide assistance to them, even in Colorado, even in this state, increasingly they find that civil justice issues, they are increasingly not at the present time resolved. And there are needs like housing, like safety, family, physical and mental health, economic security. And most people try to resolve these issues even without legal help. And despite being ill equipped to navigate an unfamiliar, complex civil justice system alone. I looked at their findings, and their findings, especially as you have also talked about vulnerable people in India, and they are. But here, even in this country, vulnerable populations that participants mentioned, they included, and these are the categories: aging adults, people with disabilities, people of color, people experiencing poverty, homelessness, mental health, or addiction. They have language challenges, as you have brought out, that perhaps vernacular languages ought to be used. They have got social, cultural, linguistic barriers, domestic violence issues. And then they said, what should be recommended? And I won't go into details, but they have talked about the Colorado General Assembly, that it ought to make all kind of efforts to increase legislative funding for Coloradans. Then about the judicial department, they have got all kind of recommendations. They have recommendations for lawyers. They have recommendations for law schools. And I think on law schools, I want to mention especially, they'll want to encourage law students to do pro bono work through programs specifically focused on providing legal services to those unable to afford attorneys and to rural Coloradans. Then they also wanted to expand incentive programs so that law students are encouraged, recent graduates are encouraged to open or join law practices in rural Colorado. Here in villages or in rural areas, still we find that people do not have adequate assistance provided to them in order to get justice. I feel very strongly that since the problem is universal, and in India you have already tackled it in many different ways, and now that the Department of Justice wants to do it in a very holistic fashion, I look forward to seeing as I come back that much more progress has been made. I'm deeply grateful to you for including me, and at the present time, it's 1:03 a.m. And tomorrow morning, here I'm in, not in Denver, I'm in Cleveland at Case Western Reserve University Law School. And tomorrow morning, in about 7 hours, 8 o'clock, I am going to be presenting on the Ukraine issue, international law, and the veto problem in the Security Council. I wish you all success in the conference. And please know that I'm looking forward again to visiting the University of Delhi Faculty of Law, my own school. That's where I studied. That's where I formed my own legal education understanding. And I'm deeply, deeply grateful to all of you. Please be well, and I look forward to seeing you. My warmest regards and very best wishes for a very successful conference. Thank you very much.
Thank you very much, sir. As you mentioned, that access to justice is a universal issue. So I hope India can set a precedent for all the other nations that will always provide fair, transparent, and non-discriminatory access to justice. Thank you very much, sir. It was an
Thank you.
enriching session. I'll now invite our guest of honor, Sri Atul Kothari ji. Sir, I request you to kindly address the student. Namaskar, sir.
प्लीज बहुत बहुत धन्यवाद। फैकल्टी ऑफ लॉ दिल्ली यूनिवर्सिटी के द्वारा आयोजित इस वेबिनार के मंच पर उपस्थित आज के इस कार्यक्रम के प्रमुख अतिथि, फैकल्टी के डीन, सम्मानीय सभी आचार्य बंधुएं बहनें और विद्यार्थी भाई और बहनों, एक अत्यंत महत्वपूर्ण विषय पर लॉ फैकल्टी ने इस आयोजन किया है, इसलिए मैं लॉ फैकल्टी के डीन और लॉ फैकल्टी परिवार के सभी का बहुत बहुत अभिनंदन करता हूं। जो आज विषय है उसमें एक लैंग्वेज बैरियर का भी एक विषय है, उसी पर मैं मेरी बात को केंद्रित करने का प्रयास करूंगा। जस्टिस रमणा ने अपने एक उद्बोधन में कहा था कि स्वतंत्रता के 74 इयर्स के बाद पारंपरिक और कृषि प्रधान देश में जो अदालतों की प्रक्रिया चलती है वो बेयर एक्ट्स की जटिल भाषा और न्याय वितरण की प्रक्रिया के बीच आम आदमी अपनी शिकायत को किस्मत के सहारे छोड़ देता है। अक्सर इस एक न्याय की खोज में आया व्यक्ति प्रणाली के लिए खुद को बाहरी महसूस करता है। आगे उन्होंने कहा था कि कोर्ट के अंदर अंग्रेजी में होने वाली कानूनी कार्यवाही को ग्रामीण समझ नहीं पाते हैं। यही कारण है किसी भी केस में उसके ज्यादा पैसे खर्च होते हैं और उनको न्यायपालिका के काम से संतोष नहीं मिलता है। तो ये इस प्रकार हमारे माननीय प्रधानमंत्री जी ने भी चीफ मिनिस्टर और चीफ जस्टिस के जो कॉन्फ्रेंस हुआ था उसमें उन्होंने भी कहा था कि मुख्यमंत्रियों हाईकोर्ट के मुख्य न्यायाधीशों के सम्मेलन का उद्घाटन करते हुए श्री मोदी ने कहा कि देश में सुराज का आधा न्याय होता है, इसलिए न्याय जनता से जुड़ा हुआ हो और जनता की भाषा में होना चाहिए। जब तक न्याय के आधार पर सामान्य मानव नहीं समझता है उसके लिए न्याय और राजकीय आदेश में फर्क नहीं होता है। आगे उन्होंने कहा कि एक बड़ी आबादी को न्याय प्रक्रिया से लेकर फैसलों तक को समझना मुश्किल होता है। अदालतों में स्थानीय भाषाओं में प्रोत्साहन देने की जरूरत है। इससे देश के सामान्य नागरिक को न्याय प्रणालिका में भरोसा बढ़ेगा। तो ये जो हमारा देश के गरीब, पिछड़े, बैकवर्ड, ट्राइबल, ये जो सारा समाज है वो हमारी न्याय प्रक्रिया से बहुत वंचित रहता है, क्योंकि वो समझ ही नहीं पाता है कि क्या न्याय दिया जाता है, क्या डिस्कशन कोर्ट में हो रहा है। हमने जब 2012 में फर्स्ट एक सेमिनार किया था इसी सब्जेक्ट पर, तो उसमें हाई कोर्ट के एक चीफ जस्टिस, एक्स चीफ जस्टिस आए थे। तो उन्होंने एग्जाम्पल देकर कहा, अपना एग्जाम्पल जो है कि मैंने एक जजमेंट दिया, तो जजमेंट में जो व्यक्ति केस में हार गया था वो और उनके एडवोकेट दोनों कोर्ट का काम पूरा होने के बाद चलकर जा रहे थे। तो वादी ने पूछा जज एडवोकेट को कि मेरे केस का क्या हुआ। तो केस तो बेचारा हार गया था, लेकिन एडवोकेट ने कहा कि जज साहब ने कहा है कि उपली कोर्ट में जाइए आप। ये एक्स चीफ जस्टिस ने अपने स्वयं के एक्सपीरियंस की बात कही है। तो गरीब बेचारा लूट हो रही है गरीबों की इसमें। और बहुत सारे एडवोकेट्स हमारे मित्र भी है कि जजमेंट आता है तो जजमेंट इंग्लिश में होता है, तो इसको पढ़कर समझाने के लिए भी इसका एक्स्ट्रा पैसे लिए जाते हैं। फिर तो आम आदमी कहाँ जुडिशियरी में खड़ा रह पाएगा बेचारा। और इतना कॉस्टली न्याय है हमारा कि हाई कोर्ट, सुप्रीम कोर्ट तक देश की 70-80% पब्लिक तो पहुंच ही नहीं पाएगी। तो ये जो सिचुएशन है इसमें चेंज करने की आवश्यकता है। और जो हमारे संविधान के व्यवस्थाएं भी है, कुछ संविधान व्यवस्था नहीं है, कुछ है। जैसे डिस्ट्रिक्ट कोर्ट, लोअर कोर्ट, इसमें स्टेट का पावर है कि वो वहां की अपनी लोकल लैंग्वेज में वहां कोर्ट में सारी बहस डिस्कशन हो, इसके लिए वो अधिकार का उपयोग करके कर सकते हैं। कई स्टेट में इस प्रकार हो रहा है, लेकिन आप देखेंगे दिल्ली, कर्नाटक, आंध्र प्रदेश, तेलंगाना, ऐसे कई स्टेट में लोअर कोर्ट में भी इंग्लिश में डिस्कशन हो रहा है आजकल। सारी बहस लोअर कोर्ट में भी इंग्लिश में हो रही है। तो ये जो 17 अधीनस्थ और जिला न्यायालयों में तो आपराधिक प्रक्रिया संहिता 272 और सिविल प्रक्रिया संहिता 137 के अनुसार वहां की राजभाषा में कार्य करने का प्रावधान है। लेकिन फिर भी आज तक देश की जो हमारा कैपिटल राजधानी है दिल्ली, उसमें हम पिछले 5 साल से लड़ाई लड़ रहे हैं। यहाँ की लोकल जुडिशरी में हिंदी में काम होना चाहिए, क्योंकि यहाँ की मातृभाषा हिंदी है, इसलिए यहाँ की स्टेट लैंग्वेज हिंदी है, इसलिए हिंदी का प्रश्न नहीं, प्रश्न सब लोकल लैंग्वेज का है, मेन प्रश्न। लेकिन अभी तक वो डिसीजन कुछ हुआ नहीं है। हाँ, हमने हरियाणा में अभी 3 वर्ष लड़ाई लड़ी, तो हरियाणा में वो चेंज हो गया और उन्होंने, गवर्नमेंट ने सर्कुलर भी इसका निकाल दिया है। तो ये संवैधानिक कॉन्स्टिट्यूशनल प्रावधान है, फिर भी हमारे यहाँ क्यों नहीं हो रहा है, ये एक बहुत बड़ा प्रश्न है। दूसरी बात है कि हाई कोर्ट की जब तक बात है, तो हाई कोर्ट और सुप्रीम कोर्ट की ये लैंग्वेज हम सब जानते हैं कि वो इंग्लिश है अभी भी। तो लेकिन उसमें प्रावधान है जो राजभाषा अधिनियम में कहा गया 26 जनवरी 65 को, कि पहले की तरह ही अंग्रेजी का प्रयोग होता रहेगा हाई कोर्ट, सुप्रीम कोर्ट में। लेकिन जो आर्टिकल 348 है, वो 348 में कहा है कि हाई कोर्ट और सुप्रीम कोर्ट, इनकी भाषा इंग्लिश होगी, लेकिन 348(2) में कहा है कि किसी भी राज्य के राज्यपाल महोदय यानी किसी भी स्टेट गवर्नमेंट के गवर्नर वहां से एक रिजोल्यूशन पास करके माननीय राष्ट्रपति को भेजते हैं और राष्ट्रपति इस पर सिग्नेचर करते हैं, तो उस स्टेट में वहां की लोकल लैंग्वेज में हाई कोर्ट में भी कार्यवाही हो सकती है। इसी के तहत बिहार, मध्य प्रदेश, यूपी और एमपी, ये 4 स्टेट में वहां की लोकल लैंग्वेज को हाई कोर्ट में भी परमिशन है। तो अगर 4 स्टेट में ये है तो बाकी स्टेट में क्यों नहीं हो सकता है? तो इस पर कई बार क्वेश्चन किया जाता है कि कुछ जस्टिस आउट ऑफ स्टेट के होते हैं, तो वो उसके लिए लैंग्वेज मुश्किल होगा समझना। तो पहला मेरा क्वेश्चन तो ये है कि आप सब इस पर थिंकिंग करें, विचार करें कि जुडिशियरी, जस्टिस, न्याय ये देश की 135 करोड़ जनता के लिए है या जजिस के लिए है? तो चलो फिर भी ये तो एक भावनात्मक बात हो गई, लेकिन इसका सॉल्यूशन भी है। जैसे आज हमारी पार्लियामेंट में लगभग 850 मेंबर पार्लियामेंट के मेंबर हैं दोनों मिलाकर, तो वहां ऐसे इंस्ट्रूमेंट की सिस्टम है कि आप वहां हिंदी में बोलेंगे तो जिस मेंबर को जो भाषा में समझना है उस भाषा में वो समझ सकता है। कोई तेलुगु व्यक्ति है तो उनको हिंदी समझ में नहीं आ रही, तो तेलुगु में वो ट्रांसलेशन उनको मिल सकता है उस इंस्ट्रूमेंट से। तो अगर 850 सांसदों के लिए व्यवस्था हो सकती है देश में, तो 24 हाई कोर्ट में ये सिस्टम नहीं हो सकता है क्या? और आज तो टेक्नोलॉजी इतनी आगे बढ़ रही है कि बहुत इजी है सब ये करना। दूसरी बात है कि मैंने पूरे देश के हाई कोर्ट का एक इनफॉर्मली सर्वे किया है, कहीं भी 10% से ज्यादा आउट ऑफ स्टेट के जज नहीं है। कहीं 2 है, कहीं 3 है, कहीं 4 है, मैक्सिमम कहीं 5 है। तो मान लो 35 जजिस है किसी हाई कोर्ट में, उसमें 3 जजिस अगर आउट ऑफ स्टेट के हैं तो 32 तो उसी स्टेट के हैं। तो जब कोई मान लो लोकल लैंग्वेज में डिस्कशन करना चाहेगा तो उस प्रकार की बेंच बनाई जा सकती है। तो ये सेकंड सॉल्यूशन है जो हो तो इजी है, कोई किसी का कोई एक्सपेंस खर्च भी इसमें तो नहीं है। और थर्ड है कि जैसे हमारे आईएएस आईपीएस सिस्टम में वो जिस स्टेट में इनके नियुक्ति होती है उस स्टेट की लैंग्वेज वो सीखते हैं। तो सुप्रीम कोर्ट के एक्स चीफ जस्टिस हमारे प्रोग्राम में आए थे, तो उन्होंने कहा कि जब मैं हाई कोर्ट, मुंबई हाई कोर्ट में था तो मेरा ट्रांसफर तय हो गया कि मुझे तमिलनाडु जाना है। तो मुझे 1-1.5 महीने का समय मिला बीच में, तो मैंने काफी कुछ तमिल सीखने का प्रयास किया उस समय कि जिससे वहां मैं लोकल लैंग्वेज से कनेक्ट हो सकूं। तय हो गया कि मुझे तमिलनाडु, तो ये भी पॉसिबल है। तो इस प्रकार के काफी ऑप्शंस है, बस इच्छा शक्ति की आवश्यकता है। देयर इज ए व्हील, देयर इज ए वे। और जब हम लोग भी स्टार्टिंग में काम किया, हमने भारतीय भाषा अभियान एक हमने खड़ा किया है कि देश भर में इसका मेन मोटो है कि जनता को जनता की भाषा में न्याय मिले। तो हमारा एक प्रोग्राम लखनऊ में था, तो हम स्टार्टिंग में डिस्ट्रिक्ट कोर्ट, हाई कोर्ट की डिस्कशन करते थे। क्षमा करिए। तो मैं उसमें मुख्य वक्ता था, तो मेरा उद्बोधन हुआ। बाद में वहां के हाई कोर्ट के जज थे, वो प्रिसाइड कर रहे थे, तो उन्होंने अपने उद्बोधन में कहा कि अतुल जी, आप डिस्ट्रिक्ट कोर्ट और हाई कोर्ट की तो बात आपने की, आप सुप्रीम कोर्ट की बात क्यों नहीं कर रहे हैं? तो उन्होंने कहा कि 22 लैंग्वेजेस है हमारी शेड्यूल 8 की, तो 22 लैंग्वेजेस में जुडिशरी अपना निर्णय दे सकती है, ट्रांसलेशन हो सकता है। इसके लिए मान लो सेंट्रल गवर्नमेंट को अगर एक 25-50 करोड़ का खर्च होता है, तो देश की 135 करोड़ जनता को अपनी भाषा में न्याय मिले, इसके लिए सेंट्रल गवर्नमेंट के लिए 50 करोड़ बहुत बहुत नॉमिनल है बात। तो ये सारे विकल्प पर विचार करने की आवश्यकता है, नहीं तो हमारा बेचारा आम आदमी, गांव का गरीब, जनजातीय, वनवासी, ट्राइबल, पीड़ित, इन सबको न्याय कहां मिलेगा? और ज्यादातर तो केसेस में वही विचारे होते हैं अधिकतर। तो इन सब बातों की दृष्टि से बहुत सारे सब्जेक्ट हैं, लेकिन समय की मर्यादा है, इसलिए मैंने सिर्फ लैंग्वेज के बारे में ही यहाँ डिस्कशन किया है। लेकिन बाकी बहुत सारे विषय है, इसका कभी और डिस्कशन करेंगे कि इतना कॉस्टली जो हमारी जुडिशरी है, कि सुप्रीम कोर्ट में तो घड़ी के नोक पर पैसे लिए जाते हैं, लाखों रुपया। तो हमारे देश के 1-2% के लिए सुप्रीम कोर्ट है क्या? तो इस प्रकार के बहुत सारे क्वेश्चन, प्रश्न है। इस पर बहुत मैं समझता हूं कि ये 2 दिन कॉन्क्लेव है, तो उसमें सारे एस्पेक्ट पर डिस्कशन होगा। लेकिन मेरा जो मेन सब्जेक्ट था कि जनता को जनता की भाषा में न्याय मिले, इस पर मैंने एम्फेसिस करने का प्रयास किया है। आपने मुझे बुलाया और मेरे विचार व्यक्त करने का अवसर दिया, इसके लिए आपका धन्यवाद। लेकिन एक पॉइंट स्लोली मैं भूल गया हूं, क्योंकि हम एजुकेशनल इंस्टीट्यूशन में बैठे हैं, इसलिए मैं इसको हाईलाइट करना चाहता हूं कि इसके लिए आवश्यक है कि हमारी लॉ की स्टडी वो भी लोकल लैंग्वेज में होनी चाहिए। जब तक वो लोकल लैंग्वेज में नहीं होगी, तो इस स्टडी, इस पढ़ाई से निकले हुए बच्चे जो टोटली इंग्लिश मीडियम से निकलेंगे, तो वो जुडिशरी में जाकर, न्यायालय में जाकर अपनी भाषा में कैसे बात करेंगे? पॉसिबल ही नहीं होगा। वो हमारी लोकल पब्लिक से कनेक्ट कैसे होंगे? वो हमारे गांव के जनजातीय, ट्राइबल, पुअर, विलेजेस के लोगों से कैसे कनेक्ट होंगे वो बच्चे? तो इसका भी एक विचार करने की आवश्यकता है, और इसके लिए हम एक 19th को एक कॉन्क्लेव भी, सेमिनार भी करने वाले हैं। आप सबको भी उसमें इनवाइट हम करेंगे 19th ऑफ नवंबर। बहुत बहुत धन्यवाद।
धन्यवाद सर। जैसा कि आपने कहा था सर कि कभी भी हमें न्याय को किस्मत पे किसी को छोड़ने का जरूरत ना पड़े, तो वैसे ही सर अब हम इसी पे काम करेंगे सर कि हमारी न्यायपालिका इतनी स्ट्रांग हो, इतनी मजबूत हो कि कभी भी किस्मत पे किसी को छोड़ने की जरूरत ना पड़े और जनता को जनता की भाषा में ही न्याय मिले। थैंक यू सो मच सर, आपका सेशन बहुत ही इंस्पायरिंग था। आई वुड नाउ लाइक टू इनवाइट आवर co-chair of the session, Honorable Mr. Justice Kannunanand Bajpai, who is a judicial member at the National Consumer Dispute Redressal Commission. Sir, journey has been extensive and inspiring. Your Lordship, I request you to kindly address our students. Your Lordship, are you on board with us? I would like to also brief about Your Lordship. Your Lordship has practiced extensively in criminal matters before taking oath as permanent judge. Your Lordship has worked as special counsel for the state of UP and also worked as an additional government advocate grade 1 in the Allahabad High Court. Your Lordship is the retired judge of the Allahabad High Court and now is the judicial member of NCDRC. Your Lordship journey is not only inspirational for law students, but it has also a lot of things to teach us and a lot of options which we have as students. Your Lordship, I now request you to kindly address our students.
It appears कुछ technical, yeah, no, he's there.
Can I hear?
Yes, sir.
Yes, sir, you're audible, please. Yeah.
Actually, there was a serious connectivity problem, so I couldn't hear. Am I supposed to speak now?
Yes, sir. You can speak now. Yes, sir.
I see.
I request your lordship, sir.
I see. Thank you. Most esteemed MM Kumar Sahab and esteemed guest of honor, Professor Nanda Atul Kothari Sahab, Shri Rahul ji, Ratna Balli ji, Professor Kiran Gupta ji, and the entire dear students and everybody in the audience. It is really, I deem it to be a great privilege to be amongst you. And after a long time being brushing shoulders with some of the best intellects of the nation, it is really a great privilege. And you know, when you come in the sequence later on, then the biggest handicap which one confronts is that probably all which is worth saying has already been said. And you really do not know. Either you are to be held guilty of duplicating and repeating what everybody has said, but then that is how the things go on. So right now, the Kothari Sahab has pointed out a few things. It is really not one word which he said can be contradicted or be denied, and there cannot be any difference of opinion in what he said. But just one thing I like to share in that regard, what he has so in his wisdom has said, that probably the access to justice is not so much dependent upon the language barrier. You know, the present system in which we are working, the justice is being administered through courts, and the process in the court is through lawyers. I may not know a word of the language, but if I have means and resources enough to approach the right counsel, then justice is available to me. If I have enough economic status to approach the top lawyers of the Supreme Court, I just have to pay them. What judgment is delivered, I may not comprehend the judgment. I may be a tribal, but if suppose by some luck I have got a lottery and I have enough funds in my coffers, I may not understand a word of the judgment which is delivered, but then the justice has already been delivered. Suppose the Ram Mandir issue has been decided by the apex court. Now it affects probably everybody who lives in the country. Those who won it, those who lost it, those who partially won it, they may not have read, they obviously have not read the judgment. And probably the masses have not understood the legal nuances, how it evolved, what has been adjudicated, but the ultimate verdict is known to them and they have availed it. Just because competent lawyers were there to argue the matter. So comprehending the judgment is actually not so much a problem and so much related with access to justice. In fact, if a person does not know, it actually ultimately goes to affect those people who are unable to become lawyers because of the handicap of the language. हमको इंग्लिश समझ में नहीं आती है, लेकिन हम बहुत विद्वान हैं, बहुत टैलेंटेड हैं, बहुत जीनियस हैं. हम बहुत अच्छे डॉक्टर हो सकते थे, बहुत अच्छे इंजीनियर हो सकते थे, बहुत अच्छे लॉयर हो सकते थे, लेकिन लैंग्वेज की प्रॉब्लम की वजह से हम नहीं हो पाए. Now that handicap has deprived me of becoming a great lawyer, though I was actually having a latent great talent to become a great lawyer. But so the question is whether I am comprehending the verdict or I am not comprehending, because everybody knows what verdict has been delivered. Of course, such anecdotes may happen that sometimes a lawyer may mislead, but then ultimately a man knows whether he has lost or he has won. So knowing the language of the court is not so much a handicap for the purposes of having access to justice, as it is the economic status. I may just add, because one of the colleagues of mine who had been elevated to the bench and was a judge in the High Court along with me, shared a bench also with me. He has retired 2-3 years back. And recently I had a talk with him, and then when I was conversing with him and shared, he said, I'm not getting my pension. He said, why are you not getting your pension? He said, he was elevated, he was from the service cadre, and there were certain issues that you belong to that category, and therefore the pension is to be reckoned from this date and not from that date. And these are the rules which will be applicable. That the basic salary is to be counted from that pay commission and this pay commission. So for last 3 years, why don't you go and file a writ in the apex court? He simply laughed. He was a man of principles. He has lived a scrupulous life. He said, if I invest the entire fortune I have amassed in my life, then only I can get a good counsel in the apex court. I can simply not afford. Now, he belongs to that vulnerable class. He has lived and retired as judge of the High Court. Now, access of justice, he's deprived of because he's not having enough resources. He knows English. He had delivered millions of verdicts in his life. So accessibility to justice is entirely a different thing. Of course, if I want to plead my own case, then of course I need to know the language. But how many people are there who plead their own cause? Except some few exceptions. Otherwise, the system which we have inherited is a system which operates through councils. This topic, actually, access to justice, especially the vulnerable and disadvantaged groups and linguistic, it is such an all-comprehensive term that probably everything which comes under the sky shall be covered in the topic. And you simply, as has been rightly done by Kothari Saab, he has to pick up just one facet of it. Because, I mean, access to justice begins how to approach. The first step is to go to the police station. Now, the barriers and the problems and the pragmatic problems with our Indian system presents to a poor or an ordinary man who goes to the approach. The struggle begins from that stage, how to get an FIR lodged. Those people who have had the misfortune of approaching a police station probably will narrate their tale of woe, how they confronted, how they managed, and how they succeeded or how they failed to get their FIR registered. Well, access of justice has been denied just because you failed to get your complaint registered in the FIR itself. So access to justice begins and has a myriad aspects associated with it. So we have to delineate and have to deal somewhere or the other. Then only we can talk with the limited time, space, and constraint which we are having. Probably when we talk of the access to justice, we are not talking of political justice. We are not talking of social justice. We are talking probably of the legal justice and the legal justice which is delivered through courts. And therefore, probably that may delimit or limit the topic to a particular way, and we can talk something about it. Actually, when we allow to dwell in the history, we find that justice delivery system in Vedic and post-Vedic period appeared much more inclusive, probably accessible and effective for the people. The social life was governed by the Dharma Shastra and Dharma Sutra, and presumably which emerged from their own inner consciousness, their own spiritual experiences, or maybe their intellectual or psychological experiences, whatever you call it, and which was largely regulated by the moral values and the ethics practice in the then society. It is believed that all law was originally customary law, and there was hardly any statutory law in the primitive or ancient India as we have it now, for the simple reason that there was probably no such parliament and assemblies as we are having now. But there was certainly a system, justice delivery system, took care of the social, cultural, economic, political aspects while pronouncing justice. And the Shruti and Smriti and the Sadachar and the Atma Santushti, all those aspects which all of you people know, were actually considered as sources of the law. The Achar, the Vyavhar, the Prashit, the atonement, all these aspects were the cardinal principles quite in vogue and were well in the practice. So access to justice was not much an issue in the ancient periods, as it stares in our face right now, which we are confronting and talking all this about. And probably the students know it much more. We have long memories. Later on, probably in the Mahajanapad period, the life of this was established, and it was quite diverse from nature, culture, and historical movements. And the centralization of judiciary began to take shape, and the king became the supreme judicial authority, probably deriving his right from the divine sources, and said, "We are the divine representatives." But the hierarchy of the court was well in place and was present. The rules and laws got codified. The Arthashastra of Kautil is one of such examples. Language of justice was formalized, probably, and the language of the court became the language of the law. However, this language was quite known to the general masses, and there was not a yawning gap between the two, and the access of justice was secure. And even that aspect was not much of a barrier, which our preceding speaker, Kothari Saab, had referred to. But then in the medieval period, when Islamic rulers invaded India, they brought their own language and the culture and the social cultural life and practices, which were absolutely different from Indian system. Persian became the language of the court, administration, and then which was alien to the masses of India. When Britishers followed, they again colonized India, they imposed English, and that was yet another alien language imposed on the people of India, especially when we talk of the delivery of the justice system. They codified the law in the same language, implemented it all across India. The absence of the knowledge of these languages restricted the access of masses to the equitable justice in probably somewhat similar way as Kothari Saab has referred to. Then the cultural and the linguistic diversity of the Indian population also turned out to be an absolute this equitable justice became a problem. Now, every cultural community has its own traditional laws, which they are practicing from times immemorial. The very basic aspect of access to justice begin with the access to the court, as we have been talking. But the poor and the vulnerable section of the society very limited or no access due to different reasons. For example, abject poverty, which I think is the most important aspect, is social and political backwardness, illiteracy, ignorance, procedural conventions, and the cost which it involves. Probably these are the things which deprive or have the major share of deprivation to their heads. Our constitution makers realized the historical mistakes and probably understood the varying aspects and meaning of the access to justice. The core idea of access to justice is very prominently embedded in the Indian constitution, which has been subjected to many modifications in the last 75 years. But the defining preamble of the constitution marks and contemplates a very wholesome beginning of access to justice by securing to all citizens of India social, economic, and political justice. They explicitly brought the provisions of equal justice and legal aids as inscribed in the directive principles also. And we know, students know it much better, that it enshrines that the state shall secure that the operation of the legal system promotes justice on the basis of equal opportunity, and shall in particular provide free legal aid by suitable legislation or schemes or in any other way to ensure that opportunities for securing justice are not denied to any citizen by reason of economic or other disabilities. Now, in a famous case, I think it was Chief Justice Thakur who had delineated some of these aspects and had observed that the state must provide an effective adjudicatory mechanism, first of all. Then the mechanism so provided must be reasonably accessible in terms of distance. That is a very important aspect, distance aspect. Often we see that the place where the justice is delivered and the places where that person belongs who seeks justice is so terribly distantly placed that probably he cannot even think in terms of going and taking up all those things. The process of adjudication must be speedy, as everybody knows, And then the litigants' access to the adjudicatory process must be affordable. That is again to be underlined. Now, to achieve the constitutional object under Article 39A, to provide equal justice and free legal aids and Legislative Services Act has been enacted, is in force, which constitute National Legal Services Authority to provide free and competent and legal services to the weaker sections of the society. It ensures that opportunity to secure justice cannot be denied to any citizen because of the economic or other disabilities. The objectives of National Legal Service, we know, are obviously, it is known again to everybody, to set up with mandate to provide free legal services to weakened sections of the society, and includes any service in the conduct of any case or other legal proceedings before any court or other authority or tribunal, and giving advice in any other legal matter. Now, organizing the Lok Adalat is also, again, one of the key activity which all of us manage and organize. Every state has district and talukas are having the legal service authorities respectively, which are actually responsible for implementing legal services in their respective areas. But perhaps it is the time to confess that despite several legislative and structural changes, it has been realized that the poor and the marginalized people have limited, seriously limited access to justice, as at the very outset was some empirical analysis and data were also provided by the speaker, that the people who got the major penalties, etc., when the statics surveys were made and the researches were made, they all were found to belonging to a particular and the most vulnerable section of the society. Now, to provide equitable justice to the marginalized and vulnerable sections, we need to re-examine and relook into the gap and address the challenges which actually restrict the poor to achieve justice. That is actually the challenge which is staring in our face. And it is for us to find out as to how are we going to succeed to tackle and successfully address them. Now, we still need to increase the infrastructural setups. I remember an episode when a lot of hue and cry was made by my Allahabad people that we are short of judges, and the then law minister, Mr. Khurshid, was there, who was a chief guest in a function. So we said that we are utterly falling short of the number. He said, all right, today is Wednesday. By Friday, I'm going to send 50 judges to you. Shall that be okay? He said, yes, 50 will suffice. Good, all right, now just let me see. Where are you going to seat them? Which shall be their chambers? Which shall be their courts? Naturally, there were neither courts nor chambers. He said, well, it is for you to develop and evolve the infrastructure first, then ask for the appointment of judges. So everything has a myriad aspects. It is not a straight away 2 and 2 into 4. We have to have a very comprehensive, a very wholesome approach towards the problem, and then only can probably we find some answer to it. So the complexity of the statutory language has been so much decried, has made the legal system incomprehensible to the common man. The language barrier limits the understanding of the layman regarding his own rights. The text and the dialect of the law and the legal proceeding should be simple, jargon-free, better understanding of the masses. But as I have already submitted humbly, that understanding is not actually the first barrier to access of justice. You, despite not knowing the language, can still have successful access to justice if you just have a deep pocket where you can afford a good counsel. The translated local and regional language copies of the High Court judgment must be made available to the litigants. That was found, even the former president, Govindji, had referred in a speech about that thing and underlined and emphasized upon the need as to how the legal linguistic nuances of the court language must be made available to the people who are actually the stakeholders of the justice system. Cost of litigation naturally required to be reduced drastically in order to make it accessible for the common poor man, as it is not possible for him to bear the burden of the complex and expensive process of the litigation. More alternative dispute resolution centers ought to be created for settling disputes out of the court, especially in rural and tribal areas. And probably before that stage comes where you go to the court, probably at the village level, at the Kasbah level, at the town level, at the district level, if you can somehow, those alternative reduce resolution centers, whether they are in the form of Gram Panchayat or Gram Nyalay or some such thing, probably that is only the way, because ultimately if everybody for small to the large cause comes to the final court, it is naturally with a population of this size, it will become unmanageable. Number, of course, again is another big aspect. How to create, how to increase, how to settle the disputes in time, how to reduce the pendency, how to resolve the issue of the stagnant pendency which some of the high courts are having. Now, the yawning gap in the constitutional jurisdiction of the district, that is also one aspect which I think deserves attention, because for the constitutional matters, it is only the High Court and the Supreme Courts which deal with these things. While thousands and millions of disputes and litigations, they involve the infringement of the rights, the constitutional right. It is not just the breach of some statutory law which brings a man to the court. Actually, these are the days of the writs, where even the violation of the human rights are to be adjudicated. And every kind of constitutional, the breach of the constitutional. Now, the district court level, one high court in one province, and the infringement and the impairment of the constitutional rights all over the state, how can it be? I mean, if this can be delegated, or if fresh powers may be, where at the district level also they are empowered to deal with the breach of the constitutional rights. That is also one important aspect, because so far this High Court and the Supreme Courts are the sole repository to adjudicate upon such breaches. That is also one aspect which deserves attention of all of us. Now, one thing which was also hinted, that the digitization of the information proceedings and judgments of the handicapped people. I mean, the voice-based kizok, which may enable the illiterate or the visually challenged people or to get information, because a large number of people are those who cannot speak, who cannot even hear. They are deaf and deaf. Now, how are we going to deal with that part of the society? That is also the most vulnerable. Probably they are the most vulnerable sections of the society. How are we going to provide them? They cannot see, they cannot hear, they cannot talk. That is also one aspect. I mean, I'm trying to speed up at least the address, if not the system of the adjudication, as much as I can. And these questions naturally can be achieved by the Indian legal service. This legal system gets Indianized. That is one caption which we may say, Indianization of the whole system. Now that has become the need of the hours, and Indianization means, basically, as our former Chief Justice Ramanna Sahab had once said, to adapt the practical realities of our society and localize our justice delivery systems in a language which they understand. Of course, that is one very important aspect. It cannot be ignored. I must not be misunderstood or mistaken when I give some reservation and my views regarding what has been said by Professor Kothari, so that they do not feel excluded to outsiders or alien to the whole process. Now, if I'm permitted to come to put an end to what has been, I think the access to justice may be said to mean approaching the courts and judicial forums with minimum obstacles and through maximum ways for seeking relief against any infringement, abuse, impairment of human rights or legal rights. Access to justice, because it no longer only refers to the basic right of litigation, but also includes the opportunity to receive redressals against the violation of human rights. I mean, that is one very important aspect now. So I think US Supreme Court Justice Powell had once observed that equal justice under law is not merely a caption on the facade of Supreme Court building. It is perhaps the most inspiring ideal of our society. It is one of the ends for which our entire legal system exists. It is fundamental that justice should be the same in substance and availability both, without regard to economic status. That is the same thing which I was trying to submit at the outset. But we can talk of the problems. Some of us may even find some solutions to it. We really do not know how long is that journey and how digressing may be the temptations and the diversions. And perhaps Robert Frost used to utter those lines, quite favorite to Pandit Nehru also. I'm also remembering those lines right now. The woods are lovely, dark and deep, but we have promises to keep. Far to go before I sleep, far to go before we sleep. I really am so honored to be amongst you erudite people. So kind of you, so patient of you. I'm really eternally grateful to you. Thank you so much once again. Thank you so much.
Thank you, Your Lordship. We are grateful for your address. You not only covered a lot of facets in such small, short period of time, you also told us that access of justice has a lot of facet and economic status forms a major role when it comes to justice delivery system. You also explained you also went into history and our present constitutional provision. I hope we are able to uphold our constitutional goals, and I hope justice, we are able to also bridge the gap. The culture, social, linguistic, all the gaps are bridged. Thank you, Your Lordship, for your thought provoking and enriching session. I would now like to invite our chair of the session, Honorable Mr. Justice M.M. Kumar, member of National Human Rights Commission and former Chief Justice, Jammu and Kashmir High Court. In J&K, Your Lordship has dealt with many PILs. He popularized the use of video conferencing, mega lok adalats, and a number of other projects. He is known to have conducted the court proceedings even during the floods in September 2014. Thereafter, he also served as the chairman, Company Law Board, and also as the founder president of National Company Law Tribunal on the abolition of the Company Law Board. Significant contribution in setting up of the Chandigarh Judicial Academy and the Rajiv Gandhi National Law University, Patiala. I request Your Lordship to kindly address our students.
Thank you so much, Ms. Mahak.
Thank you.
My esteemed brother, Mr. Justice Bajpai, the co-chair of the session. Professor Nanda seems to have left. Our guest of honor, Shri Atul Kothari, our again guest of honor, Shri Rahul Goel, our special guest, Professor Usha Tandon, who has been present throughout, Professor K. Ratnabali, and Professor Kiran Gupta. Respected faculty, our teachers, students, ladies and gentlemen, I feel extremely privileged amongst the learned gathering of eminent jurists, social activists, and learned professors. The technical session today has pondered over a very important topic concerning access to justice in the context of vulnerable, disadvantaged groups and linguistic barriers. We have brainstorming discourses from Honorable Mr. Justice Bajpai, Shri Atul Kothari, and Shri Nanda, who has spoken at length with regard to various factors which are hampering the access to justice. In fact, as Justice Bajpayee have said, the one who speaks at the end face many difficulties, because most of the things which I might have noted that I would speak have already been spoken. Therefore, there are few things which I would like to add. You see, major problem which our country faces is with regard to access to justice is the infrastructure and manpower. There is no dearth of law. Parliament passes an act. As Justice Bajpayee was mentioning that Shri Salman Khurshid at Allahabad told the audience that from where the courtroom are going to come, from where the infrastructure would be available. After all, you need stenographer, you need lawyers of that quality. All that is required. You see, the acts by the parliament, statute by the parliament, one after the other, are passed. And they stand like a flyover without access roads. Justice Siraj Joseph used to say, flyover all over the country, but they don't have access roads. Then he would quote examples of various acts passed by the parliament. The reason parliament passes a law, but there is no impact assessment. What type of resources would be required for enforcing the provisions of the statute? You may recall, amendment in the Negotiable Instrument Act came, 138 complaint. This was criminalized, and the criminal complaint filed in millions and millions before the magistrates. Where was the infrastructure? Where was the impact assessment? So naturally, the justice clogged. Access to justice stopped. What a poor magistrate would do if he has 500 complaints listed before him. How can he decide? So one thing which I would emphasize, that impact assessment must be made as is prevalent in many other countries, so that we may work within our financial resources, our infrastructure resources, manpower, etc., etc. When I was working as President National Company Law Tribunal, I faced this problem. Buildings were not there. There was insolvency bankruptcy code came in on 1st of December 2016. There were not many advocates who have adequate knowledge of the subject. Members did not have the knowledge. The colloquium after colloquium we held, we invited people even from abroad through video conferencing or otherwise, that the subject is understood. People who have background of company law, they were able to do much better. You see, so this is one thing which I recently, the Human Rights Commission is taking up the mental health care subject as a core subject, and Mental Health Act 2017 has been enforced, but it has not been, you see, implemented. But to talk of letter and spirit, even on papers. It contemplates setting up of a state mental care health authority. Many states that has not been done. Boards are required to be established, which has the responsibility to register all the mental health care worker, mental health care institution, and which fulfill the particular standard. The regulations have not been adopted, although standards by the central government have been provided. All these difficulties, 2017 we are in 2022. We visited Agra, we visited Gwalior, we visited Ranchi. Huge tract of land. Ranchi, for example, 700 acres of land for mental health care center, but hardly any facility. So somebody have to awake from the slumber. The processes, the legal processes have to be more effective, and the impression which is created by my Lord Justice Sirek Joseph that we have flyover without access roads. It was said about 10 years back when he visited Chandigarh Judicial Academy. About 10 years back, these words were uttered, and I can't forget. And it is because of lack of impact assessment. The second issue is my brother Justice Vajpayee has mentioned about Legal Services Authority. Recently, the Chief Justice of India, Honorable Mr. Justice Lalit, at Nagpur, has given a clarion call to all the Legal Services Authority to be more effective and galvanize their efforts to deliver. Now, the Legal Services Authority in the states are headed by one of the senior judge of the High Court, and they try to reach out to the vulnerable and disadvantaged groups. The process which I followed when I was in Punjab, in every college, every institution, we try to open a legal literacy club. The advantage was, once you have a legal literacy club, you have trained paralegal volunteers. There is an institution now of paralegal volunteers who are capable of guiding any citizen about their rights, drafting an application, sending it to the authority concerned, making it easier for them to have the problem resolved. So this was one way the legal services authorities have been functioning effectively. And to share with you my own experience in Punjab. In Punjab, there is an area where people are extremely fascinated to go abroad, Waba area. Everybody wants to have a foot in the foreign country, UK, Canada. Now, this set of people were sent to 50 people were sent to Dubai on the promise that they will have white collar job. And they spent huge money paid to the travel agents. When they landed in Dubai, their passports were taken away. They were asked to go to Kuwait or Iraq. What was their job? Their job was to clean the land where some ballistic missiles were planted by US in the previous war. Two of them were blown out. A public interest litigation was filed in Punjab and Haryana High Court. I was acting Chief Justice. It landed before me naturally. Then we asked the Ministry of Foreign Affairs to locate these people and bring them back. Eventually, the embassies collected these people and sent them back. When they reached Delhi, two other persons who were to fly to Dubai, they were stopped by this group not to fall in the trap. So these 42 people were trained to become paralegal volunteers. They were sent as ambassador of Legal Services Authority to spread the legal literacy amongst the masses, that this is how they were trapped, this is how they should not fall in this type of traps. So the paralegal volunteer, I think, is one institution which needs to be strengthened further. The training which we impart to them, give them educate knowledge, equip them with the art of writing small applications. For example, midday meal, old age pension. There are so many schemes unrolled by the central government which are not reaching the masses because a vulnerable section or the weaker section, they don't have any knowledge of those schemes. And the paralegal volunteers who are quite well equipped because of the training given, they can come to the rescue. I was in Anantnag, Legal Services Authority, Jammu and Kashmir has organized a program. This was personal contact program by the Legal Services Authority. So two very old women, when I finished the function, they came to me, said, we are senior citizens not getting pension. So I immediately asked my secretary to have their representation made. The district magistrate was there to hand it over to him and follow it up. Then after 2 weeks, we came to know that pension has been given. So the personal contacts program by the Legal Services Authority, reaching out to the people. There are so many other examples where we have been able to reach out to the people, offices of the Legal Services Authority. Another experience which has been mentioned by Mehak, in Srinagar in 2014, September 2014, flash flood visited the city of Srinagar. The Lal Chowk area was in 18 feet water and the district courts are situated near Lal Chowk, which was in 18 feet water. High Court was in 10 feet water and my own house went in 8 feet water. We were rescued at 2:15 early morning of 7th of September 2014 and were kept in Harinivas, which is a higher ridge area. This is a state guest house. So then I sent letters to the Honorable the Governor and the Chief Justice of India, Law Minister, requesting them that because of the flood, the court functioning must not stop and rights of the people, access to justice must not be hampered. The Chief Minister was sent the copies of those letters. Then after a few days, Chief Minister showed his inability after cabinet discussion, and we were left with hardly any option. Then I had a meeting with the honorable judges where I found that one house at Gupkar Road, which was high ridge area, was allotted to one judge which has not been occupied. 5 Kupkar Road. So I got a resolution passed that the transit seat of the High Court during floods will be the 5 Kupkar Road. And there we started functioning. And I tell you how the access to justice remained open and how it helped. Large number of insurance cases were filed. And the insurance company would argue that without the surveyor report, we cannot award any money, any compensation to the flood victims. There was a policy of a small shopkeepers where the provision was that 50% of the amount be disbursed without even surveyor report. Expanding that policy even to the large business establishment or houses, we passed an order saying that surveyor report or no surveyor report, 50% be disbursed. As a result, the whole area around the polo ground, Lal Chowk, that came back to the normalcy, and the whole market was open. But there was some reservation on the part of the insurance company because they had to shell out something like 300 crores. They thought that it was judicial overreach. My order was tested in the Supreme Court. SLP was dismissed because Justice Dattu, the then Chief Justice of India, visited Srinagar and have seen the conditions with his own eyes. And the Attorney General of India kept arguing, but SLP dismissed. Now the result is, when I went back in 2018, some of the insurance company executives came to see me. They told me that after the order was passed, the number of insurance cover in the valley has gone almost 3-4 times. This is the beauty of providing access to justice. This is the beauty of giving effective relief at the most crucial time. So on the one hand, people develop faith in the system. On the other hand, they got the benefit, they came back to life. Otherwise, 2 years, 1.5 years was the time being given for the survey report to come. So this is one experience. The other issue which Shri Kothari raised with regard to language barrier, I would agree whatever Shri Kothari have said and my brother Justice Bajpai has pointed out. Language barrier, I find in Punjab, all trials are held in Punjabi, whether civil or criminal. In Haryana, in Hindi. And in Jammu Kashmir, in Urdu. Sometimes I would face difficulty because the evidence is recorded in Urdu. If I am to hear, so ultimately I started referring the cases where the evidence was in Urdu to the local judges who have elevated from Jammu and Kashmir. So it is true that language play a pivotal role, but with the advancement of technology, as Brother Justice Bajpai have pointed out, with the Parliament, Mr. Kothari himself has said, Parliament has the translator readily available. You have to pick up the pen and put it in your ears. So there should not be any barrier with regard to the language. Artificial intelligence is another area. In NHRC, we receive complaint in Udiya, we receive complaint in Tamil Nadu. We called the NIC people who have developed the software for Parliament, and they are developing the same software for NHRC. So language problem, because of the technology, may not hamper access to justice, and as such access to justice is not hampered because of the language problem, as Justice Bajpai has pointed out. I think very aptly said that language problem is not hampering access to justice. Even when I was holding the flood court, large number of illiterate people will come. I had provided 2 writers on a plain paper. They will write for them in their own language, even in English translated language. They will present the petition before us, which would be without any stamp, etc. We will pass order with the result, with the rider that stamp duty, etc., will be affixed later when the situation come back to normal. So language problem can be, now in NHRC we are even exploring the possibility of a drop box, voice box. The voice box is open. Anybody in the country or abroad may speak in the voice box, and it can transcribe in words, and the complaint can be registered. So there, technologically we have advanced. So this can be taken care of, technologically speaking. One very important issue which I would like to discuss is related to constitutional law. You see, during the initial years of independence, Prime Minister Nehru wanted agrarian reforms. And when Land Ceiling Act or various agrarian reforms came, the High Court at Patna, High Court at Allahabad, other high courts started striking down the provisions of that act, being violative of Article 31, 91G, and others, Article 14. The President Nehru was very, very keen that agrarian should come. We should have a socialistic pattern of society. Land should not be hoarded. It should not be concentrated in few hands, as is provided by Article 39B and C, the directive principles. So he brought Article 31B, First Amendment of the Constitution, and 1951. And 31B provided that if by amendment of the Constitution any act is put in 9th schedule, it would be not challengeable on the anvil of Article 14, 19, 21 and other articles. Now for some time, the 9th schedule served its purpose in the sense that, generally speaking, some of the Agrarian Reforms Act were put in there. But later, every type of statute which did not have that content also started coming in 9th schedule. And the high courts started striking down the provisions of such articles, such acts. Then the question arose before the Honorable Supreme Court whether after Keshwananda Bharati's case, which have laid down the principle of basic structure of the Constitution, we should continue to allow 9th schedule to be used for every act and keep it beyond the challenge. Particularly after controversy on right to property under Article 31 has come to an end, it was thought that it is no longer necessary that they are immune from challenge under Article 14 1921, or other parts of the Constitution, as long as they violate basic structure of the Constitution, ninth schedule will not provide them protection. This is IR Kahlo versus State of Tamil Nadu, 2007, 2 SCC page 1. It's the 9-judge bench judgment. It also provides access to justice because 9th schedule, in some Professor Tripathi used to say, Professor Tripathi of Delhi University, he used to say it has become a graveyard of all illegal and unconstitutional statutes. So now even that has become, it is I think, a landmark judgment, a celebrated judgment, providing access to justice for challenging all those statutes which do not conform to Part 3 as long as they are part of the basic structure of the Constitution. So I think this judgment is unanimous judgment by 9 judges. Justice Sabharwal has authored the judgment. It is a landmark in the sense that now no unconstitutional law can be kept. The only thing which has been said is that if the vires of an act before 24th of April 1973 have already been challenged, upheld, then cannot be challenged again. If a vires of the act were challenged and later on it was put in 9th schedule by Parliament or by the State Assembly, then it can still be challenged on the anvil that it violates the basic structure of the Constitution. Friends, I think the time is up. I have taken much more time than my allotted time. I express my deep gratitude to Professor Usha Tandon and the Delhi University for providing me this opportunity and for granting me patience hearing by everybody. Thank you so much. Wish you all the best. Thank you.
Thank you, Your Lordship. Thank you, Your Lordship, for sharing your experiences. Even, when you shared about the flood experience in 2014, which is one of the most difficult situation a human can face, which is a natural calamity, how you opened the door of justice, how the access of justice was even available to people at that time. This is inspirational to us. This is inspirational to this generation. I hope your work will always inspire us. And now I would like to invite Mr. Rahul Goyal. He was held up in an online meeting before a last minute meeting, so he could join us later. If Mr. Rahul Goyal, sir, who is a partner at prestigious firm Anant Law, and he has an immense domain knowledge and competition and TMT laws. Sir, if you would like to address the students now.
Thank you so much, Meg, for this.
Thank you.
Honorable Mr. Justice M.M. Kumar, Member Human Rights. Honorable Mr. Justice K.N. Bajpai, Professor Ved Nanda, Shri Atul Kothari ji, Professor Usha Tandon, Professor Ratna Bali, Professor Kiran Gupta, and professors and faculty members of University of Delhi, Faculty of Law, eminent guests and students of the University of Delhi. Namaste and very good afternoon. I understand that the next session is at 12, so I would only have 5 minutes. And I'm also seeking permission of the chairperson of the session, Mr. Justice Kumar and Justice Bajpai, if I can have the last, opportunity to speak after your lordships.
No problem. No problem.
Thank you so much, sir. It's a rare privilege to be here on this platform alongside such eminent jurists and judges and professors from the University of Delhi. Thank you so much for inviting me for this eminent event commemorating 100 years of University of Delhi, which also happens to be my alma mater. Also, I would like to apologize for not being able to attend previous sessions due to a court hearing, which I had to attend at 10:30 in the morning. I had the privilege of attending yesterday's inaugural session in the August audience of Mr. Justice Call, Honorable Minister of Law and Justice, as well as our Solicitor General of India, Mr. Tushar Mehta. I think one thing that came out from that inaugural session was very clear, that while we are celebrating Azadi Ka Amrit Mahotsav, 75 years of independence, the topic that has been chosen by the University of Delhi Faculty of Law for this particular event is the most appropriate one. Today we are talking about Indianization of the legal system as well as the education system. Well, at this panel, I can safely say that I am the youngest and possibly the only student of law. Rest all are professors and jurists and judges. And in short, if I may call all of them, they are the gurus of this world, for a lot of us. Being a guru is a real honor in the Indian education system. If I can quote the Vedic saying, Guru Sakshat Parabrahma, which is Guru is Brahma, Guru is Vishnu, and Guru is Maheshwara. And therefore, a lot of onus is now, entrusted upon our educational institutions and the gurus coming out of these institutions. And access to justice cannot be achieved. Cannot be achieved only by the practitioners or the judges. The educational institutions have a huge role to play in terms of access to justice, in terms of technological developments, in terms of removing linguistic barriers, in terms of imparting knowledge. What we have seen in the past, that over the past 2.5 years, the access to justice and the access in real sense to the court system has improved significantly. Large part of it can be said to be because of COVID-19, when a lot of our courts, tribunals became virtual, and the lawyers from across India, from any corner of India, could attend the hearings in a virtual mode. Also, what it enabled was that the litigants themselves could also see the court and the court functioning, and also could hear the arguments without being required to travel to the major cities or the capital city of India to hear the cases. And that, I think, is a very major development which happened largely because of COVID. And also, a lot of effort was made by the judiciary, by the Supreme Court of India and the high courts at the state level to kind of implement the system. One thing which I really would like to compliment this entire accessibility of justice and how it functioned was that in a lot of these virtual hearings, the platforms also enabled subtitles, which were mostly in English. Now, one way of improvising the system, and this is an ongoing debate, how do we localize and Indianize the entire education and the legal system. The first and the foremost system, and I think this has already been discussed and talked about by the previous speakers, is to have access to the text, to the judgments, to various proceedings in the local language. And now with the technological development, when the subtitles can be provided in English, there could also be a possibility of providing subtitles in the local vernacular languages. And if this were to happen, I think the first stage here would be that a person who is little literate, who can read but cannot understand English properly, would be able to summarize and see what the arguments which are being advanced and what are the questions which are being put by the judges. There is a lot of literature which is available, which people from rural India read, which is Vedic literature, the Shastras and the Vedas. And there is in real sense, some of them have a very significant impact in terms of how we live today and how we socialize in the real sense. So there could also be one of the things that can be done in terms of accessibility is to have some modules created at the university level, wherein some of these things can be attached and can be clubbed with the modern legislations, largely on the principles of equity, fairness, natural justice, wherein there's a lot of text available from the ancient Indian Vedic scriptures, and to kind of guide students so that they understand that what really the Indian legal system was prior to the Britishers introducing the new system. technology can play a very significant role in this. I don't think that digital divide really remains a significant challenge as on date. A lot of development has happened. I think there is a requirement of some improvement, but my sense is that possibly in next year or two, the way the Supreme Court is now looking at improvising the system, we would have this digital barrier also removed. The new education policy of 2020, which has already been implemented and is in place and is being now utilized by various universities, including University of Delhi and Faculty of Law, can also play a significant role in terms of educating the youngsters, the students who are the future professionals and judges and the lawyers of this country to implement and to kind of utilize it in terms of localization of the Indian system as well as access to justice. Considering that we are already at 11:58 and the next session is likely to start in 2 minutes, I would like to end my talk here. And thank you so much for this opportunity, and my sincere apologies once again for getting late for this session. And I thank you, the chairperson and the co-chairperson, for allowing me to speak at the end. Thank you so much. And thank you, Faculty of Law, Professor Tandon especially, for allowing me to be part of this event. Thank you so much.
Thank you very much, sir. And now I would like to invite Professor Dr. Kiran Gupta from Law Center to Faculty of Law to deliver the vote of thanks.
Namaste to all. We are actually really honored to have such a distinguished galaxy of legal luminaries and others who are the speakers in the today's first technical session titled Access to Justice to Vulnerable Section and the Linguistic Barriers. In the conclave, 3-day conclave, organized by the Faculty of Law as a part of centenary celebrations of University of Delhi. We are honored to have all the speakers with us today, and we are very, very thankful to all of them for sharing their views, their experiences, and guiding us. As the member of the legal institution, they have guided us. My special due are for Justice Mahesh, member of the NHRC, and also the former Chief Justice of the Jammu and Kashmir High Court, for highlighting the main points in access to justice for all. Like he has said that for providing justice to all, we need good, better infrastructural facilities, in the sense that we must have good buildings, we must have proper staff, we must have educated lawyers to help the court in providing justice to the poor. He has also emphasized the role of national legal services authorities and the role of the law students as pro bono associates or as PLVs to approach the vulnerable section of the society, to go to them and help them in drafting or in otherwise writing their complaint, and after that taking their case further with the pro bono lawyers, etc. I would like to tell Justice Mahesh that all these works are going on in the University of Delhi Faculty of Law. We have legal aid clubs, we have legal aid society, we have pro bono club. We are part of pro bono club scheme of the Ministry of Justice. Our students are doing all that. They are actively participating in that. Sir, you have reminded us, actually you made us nostalgic by reminding us about Professor Tripathi. We are the students of Professor Tripathi by referring to that Schedule 9 statutes. You have shared your experience and made it clear that how providing timely justice is relevant for the society. Justice delayed is justice denied. It is a fact. We are highly obliged and thankful to you, and we pay our gratitude to you, sir, for enlightening us with your words of wisdom and with your experience. My thanks are due to Justice Karuna Nand Bajpai ji, who is presently a judicial member of the National Consumer Dispute Redressal Commission. He has also enlightened us with examples, his own examples, that how we can achieve access to justice. And he said that actually it is not dependent on the language. Language is not a major issue, major barrier to providing access to justice, but it is the economic and the social status of the person seeking justice. And it is true, we can provide justice to all only and only if we can make some arrangement to give justice to the vulnerable section, like the children, women, and the weaker section of the society. Otherwise, we having the courts and all that is irrelevant. He emphasized on the importance of organizing lok adalats in which we can solve 23 lakhs cases in a day, which all our courts might not have been solving in an year. So we have to think about that also, alternate modes of providing justice. It may be lok adalat or mediation or conciliation or arbitration. And of course, role of the legal institutions in doing all that services. We are thankful to Professor Ved Nanda ji, who is a visiting faculty in our own faculty. He has given he emphasized on the fact that access to justice is a universal problem. It is not just the issue in India. And he gave us the international perspective for the steps taken at the international level for access to justice for all. And since he has worked in various international institutions and visited number of countries, and is actively engaged in providing access to justice, his inputs are very, very relevant and important for us. We are thankful to Manya Atul Kothari ji for emphasizing the need to provide justice in the language which is understandable by the person who is seeking justice. His statement that जनता को उनकी भाषा में न्याय दो, referring to the Prime Minister and referring to the former Chief Justice Ramanna, is actually very, very relevant. Unless we know the language of the court, we can't seek justice from the court, even though the court is doing justice. But we cannot be grateful. We cannot express our gratitude to the court unless we know what the court has done for us. And that we will do only if we know the language of the court. So we are really thankful to Kothari ji. We are thankful to Mr. Rahul Goel for enlightening us about the role of educational institution in providing access to justice and the need of accessibility to justice. Access to justice actually means accessibility to justice. Unless justice is not accessible to us, we cannot seek justice at all. So we are thankful to him also. We are thankful to our Dean, Professor Usha Tandon, Professor Ratnabali. We are thankful to our team of faculty members, and special thanks for Mehak and Rahul, our students, who are the masters of today's ceremonies. We are deeply grateful to all the participants who have either joined with this link or they are part of this program, which is being telecast live on YouTube. So my thanks are to all participants, all the speakers, all the persons present here, which makes this session a successful session. Thank you all, and namaste once again.
Thank you, everyone. Namaste. I would
Thank you,
like to
Lordship. Thank you,
the
Justice Kumar, Justice
chair of this session.
Vajpayee. Thank you, sir. Thank you for enlightening us all. Thank you, Kothari sir, Rahul ji, Nanda sir, of course. Yeah, we could understand.